Welcome to the Herbert Vaughan Academic Program. Mr. Vaughan was a 1948 graduate of the Harvard Law School who practiced law with distinction for 47 years at the Boston law firm of Hale and Dorr, which is now Wilmer Hale. Mr. Vaughan endowed this program to, in his words, promote and advance understanding of the founding principles and core doctrines of American constitutionalism. He asked that this statement be read at the beginning of each of these events. In my judgment, the Constitution of the United States is the greatest practical achievement of political science. It is a testament to the extraordinary gifts of creativity, prudence, and high-mindedness possessed by the founders of our nation. May you be guided and inspired by their genius as you meet the challenges of the present day. We're honored to have the Vaughan Lecture presented this year by Professor Adrian Vermeule, the Ralph S. Tyler Jr. Professor of Constitutional Law, and the author of many books, including most recently, Common Good Constitutionalism. His lecture is entitled The Original Scalia. After Professor Vermeule's lecture, we will have comments first by Judge Andrew Oldham, a 2005, I believe, graduate of the Harvard Law School, and a judge on the United States Court of Appeals for the Fifth Circuit. Then by Professor Lawrence Lessig, the Roy L. Furman Professor of Law and Leadership. We will end no later than at 1:45 p.m. I know that some of you must leave earlier than that for class, so I ask that you do so orderly. So I would like to turn it over to Professor Vermeule. Thank you.
Well, thank you, Professor Goldsmith, for that suitably efficient introduction, given our time constraints. Yeah. And I want to thank our panelists for participating. It's very kind of them with their busy schedules, and I look forward to their thoughts. I would like to ask us all today to participate in a thought experiment, more precisely, a kind of exercise in heroic forgetting. So I want to ask us all to put aside everything we think we know about Justice Scalia's jurisprudence and imagine we are reading his body of work as of roughly the late 1980s and for some time after. I will call this version of Scalia Original Scalia. As we will see, Original Scalia turns out to be remarkably different from the Scalia who emerges towards the end of his career and who quite definitely dominates around 2013 to 2016, a version I will call Evolved Scalia. My basic claim will be that Original Scalia advanced a view of public law with two notable features. First, it's entirely consistent with the approach to legal interpretation advanced in the classical legal tradition. Indeed, it is expressly premised on the views of Aristotle, who in turn powerfully influenced St. Thomas Aquinas and the civilian lawyers of the tradition. Although my approach here is emphatically not biographical, but instead based on hopefully objective interpretation of Scalia's published work, both judicial and academic, I note that Scalia had a thoroughly classical education at a Catholic high school and at Georgetown University in the 1950s. We should hardly be surprised to discover that his thinking was deeply influenced by that milieu. Second, Original Scalia takes an expansive view of executive power in the administrative state. Indeed, he defends a view, one with deep classical roots, according to which the executive and the administrative agencies represent the living voice of our law. This is an account of the American small c unwritten constitutional order that translates and adapts the classical approach to the circumstances of our own institutions. Now, Evolved Scalia to some degree abandoned or qualified these commitments. In my view, the transition from original to evolved Scalia is a kind of synecdoche, or a summary, of a profound transition in the conservative legal movement over roughly the same period, resulting in American legal conservatism becoming increasingly focused on criticism and limitation of the administrative state. Hence, my focus will be on the role of the administrative state in Scalia's thinking, not only because that is my favorite area of law and legal theory, but because that topic has become ground zero for any number of current legal conflicts. Okay, let me start with a remarkable period, 1988 to 89, which in my view is a kind of annus mirabilis, a kind of miraculous year in the sphere of law. Justice Scalia published no less than 4 major academic articles, all of which are still highly influential in public law theory today, while simultaneously writing some of his most influential opinions. So in that year, Scalia published The Rule of Law is a Law of Rules, a famous article about legal interpretation in which I will claim his view of judicial interpretation of the law expressly tracks that of Aristotle and Aquinas. Second, judicial deference to administrative interpretations of law, a leading defense of the Chevron principle of deference to administrative agencies. That's an article that still structures our debates about Chevron. Here and elsewhere, original Scalia advances a vision of administrative agencies as the authorized dispensers of what classical lawyers would have called equitas or epikeia, specific adjustments necessary in hard cases when general rules of positive law are ambiguous, silent, incomplete, or absurdly broad in the circumstances. Third, he published an article called Assorted Canards of Contemporary Legal Analysis, an article that, among other things, offers a withering criticism of clear statement rules in terms that would easily cover the court's recent use of a clear statement rule called the Major Questions Doctrine that is designed to limit agency regulatory authority. And fourth, he published Originalism, the Lesser Evil. This is a defense of originalism, but principally on public interest grounds, grounds very different than those that later became dominant when originalism took what people have called a jurisprudential turn to more abstract justifications. And finally, in 1988 and 1989, on the judicial side of his work, Scalia wrote separate opinions in Webster v. Doe and Green v. Bach Laundry that appear in a dozen case books. I mean, they're absolutely canon. And they tried to write into our public law the classical distinction between two senses of law, lex and use, IUS, between posited civil law and general background principles of law not rooted in any particular positive enactment. So taking these sources together, I'll try to outline a coherent interpretation of original Scalia. Now, of course, as with all interesting and complicated legal thinkers, coherent interpretations are inevitably somewhat selective. There were latent tensions within Scalia's thought all along, and multiple strands not wholly consistent with one another, and these strands overlapped at any given time, so we have the wheat and the tares growing up alongside one another. Still, there is, I believe, a plausible reconstruction of the basic thinking of original Scalia that I will call the model of administrative equity, and that is entirely consistent with the classical tradition and inspired by it in important part. All right, to understand this model, we have to begin with the classical approach of Aristotle and St. Thomas Aquinas, who closely tracks Aristotle in this regard, and of the jus commune, the mainstream of the classical legal tradition that heavily influenced the Anglo-American common law. This classical heritage is a direct and explicit influence on original Scalia. What he adds is a kind of interpretation or adaptation or development or translation of the classical heritage for the circumstances of the modern administrative state. The baseline idea of the classical approach, as Aquinas argues, quoting and citing Aristotle, is that laws framed in general terms as rules conduce to the overall good of the community. Although ideally, Aquinas says the animate justice of the living judge, Judge Oldham, is better than the inanimate justice of the laws. The problem is that the animate justice of the judge is not found in many men and can be distorted by bias or ignorance. Therefore, it is necessary, whenever possible, for the law to determine what the judgment should be and for very few matters to be entrusted to the decision of men. Quoting and citing Aristotle again, Aquinas therefore proceeds to defend the proposition that it is better that all things be regulated by law than left to the decisions of judges. Both Aristotle and Aquinas, in other words, urge that lawmakers should formulate general laws that address the central or most common cases, and then interpreters should follow those rules insofar as possible. So in the classical view, there's a strong baseline presumption in favor of adherence to general rules of written law. The problem, however, as both Aristotle and Aquinas immediately go on to emphasize, is the limits of the legislator's foresight and the inevitable indeterminacy of general language. Aquinas puts it this way. He says, since the legislator cannot make provision for every single case, he frames the law according to what happens most frequently, directing his attention to the common good. Moreover, even if a legislator were able to take all cases into consideration, it would not be suitable for him to mention them all in order to avoid confusion. So we have two problems. No legislator can foresee all future cases, and no language can, under real-world conditions, perfectly express or capture all possible qualifications and exceptions. And that means that hard cases inevitably arise. And in these hard cases, the reasoned ordination of the legislator for the central or most common cases is ambiguous or silent or fails to track the general welfare in some way. What to do in hard cases of this sort? Well, the classical tradition then argues that the interpreter must apply what Aquinas called dispensations. And this is not quite, but a development of what the Roman lawyers called aequitas, and what Aristotle calls epikeia, the case-specific adjustment of vague, ambiguous, incomplete, or overly general language to particular circumstances, in order to promote the public regarding ends the legislator had in view. Don't too quickly assume here that the relevant interpreter is a judge. As we will see shortly, that's a crucial question for both the classical tradition and original Scalia's modern rendition of it. On the classical conception, the interpreter applying epikeia emphatically does not step outside of law or do something other than law. Rather, the classical view systematically distinguishes two different senses of law: lex, the positive written civil law, and use, general and traditional background principles of law writ large, like no man shall profit from his own wrongs, a classical one. This is a distinction that is preserved in many European languages to this day, ley and derecho in Spanish, for example. In English, we get confused because we use a single word law ambiguously in both ways. And then we bring in the word rights in equally confusing ways. As we will see, however, Scalia expressly tries to distinguish the two senses of law along classical lines. So this classical concept of use draws upon law in the larger sense to resolve ambiguities, interpret generalities, or otherwise clarify, limit, or supplement law as lex. On this view, to call upon use is not to have recourse to something outside the law, it's just to do law. It's a way of doing law in a certain domain. It's the application of background principles of law to interpret positive civil law and to further its aims. So this is why Aquinas speaks of dispensations as departures from the letter of the law, but not from the law itself. Just as generations of American classical lawyers and judges would later distinguish the letter of the statute from the statute itself. That's a pair of formulations that appears all over the case law, and it's a locution that sounds bizarre and self-contradictory to the modern textualist. How can you depart from the letter of the statute but not from the statute? But it points towards the distinction between law as lex and law as a use. A final crucial question for the classical approach is who decides? Which legal actor or tribunal is authorized to make dispensations or apply aequitas or epikeia? Here, Aquinas is especially instructive, and original Scalia's account directly tracks Aquinas' account and translates it to the American constitutional order. At least in non-emergency cases where there's no sudden risk, Aquinas states that dispensation may be granted only by those who are vested with authority to do so. The who decides question, then, is just another question of the interpretation of the law in both senses. There has to be some legal actor in the system with the power of dispensation or epikeia for hard cases, but judges need not be that actor. The judges may conclude that the law, again in both senses, itself vests that power in other legal actors, such as, and you can see where I'm going and where Scalia will soon go, executive magistrates, or in our terms, the president and administrative agencies. The classical law put it this way, describing the urban praetor, a magistrate lacking the formal authority to enact a law, nonetheless has the authority to aid, supplement, or correct the civil law in the public interest. The resulting body of magisterial law is, the classical jurists say, the living voice of the civil law. Okay, so much for the basic structure of classical legal interpretation. In the scholarship written during his miraculous year and his opinions the same year, Scalia follows this path of thought in quite express terms, step by step. It is just that current American law professors, many of whom are unfamiliar with the classical legal heritage, have failed to understand the background influences on Scalia's thought. So in the rule of law is a law of rules. It's okay, huh? In the rule of law is a law of rules, Scalia begins with the famous image of the animate justice of the judge. So this is the first step. And he starts with St. Louis IX of France, dispensing case-specific justice under an oak tree. But for Scalia, as for Aristotle and Aquinas, given that most interpreters are not saints, general rules of law are preferable. That's step 2. Step 3, however, is that interpretation according to general rules isn't always possible. This isn't some sort of inference. This is all what Scalia himself says. He writes in the Law of Rules article, and I'm going to quote, "In his Politics, Aristotle states, rightly constituted laws should be the final sovereign. And personal rule, whether it be exercised by a single person or a body of persons, should be sovereign only in those matters on which law is unable, owing to the difficulty of framing general rules for all contingencies, to make an exact pronouncement." So the passage from Aristotle that Scalia selected for quotation here was close to his heart. He concludes the main argument of that lecture or article by repeating the whole quotation in full, including the part about the difficulty of framing general rules for all contingencies. And then he says, quote, "I stand with Aristotle, which is a pretty good place to stand," unquote. The passage summarizes very crisply both sides of the classical framework, both the presumptive textualism of general rules and the inevitability of hard cases where rules are indeterminate and call for aequitas, epikeia, or dispensation. And Scalia returned to this at the end of his lecture saying, "Let me call attention to what I have not said. I have not said that legal determinations that do not reflect a general rule can be entirely avoided." So for Scalia, the starting point in some ways of the problem of interpretation in the administrative state is the inevitable indeterminacy of positive texts, positive rules of law. And the question, what fills in when positive rules of law are indeterminate? And as I'll now try to show, what fills in when positive law is indeterminate for Scalia is use, general background principles of law. To see this, we have to see something that I think may shock some of us. Original Scalia emphatically denies that the duty of courts to follow the law implies that courts do not make policy judgments. For original Scalia, policy and law are not contraries or antonyms. Rather, the making of policy judgments is itself part of the traditional practice of legal adjudication. To further this point, let me tax your patience with another quotation. This is an absolutely critical passage from Scalia's Chevron article. And I suggest it's classical both in express terms and in its overall thrust. Scalia writes, "The traditional tools of statutory construction include quite specifically the consideration of policy consequences. Indeed, that tool is so traditional that it has been enshrined in Latin. Ratio est legis anima, mutata legis ratione, mutatur et lex." The translation of this, which Scalia gives, is the reason for the law is its soul. When the reason for the law changes as well. And Scalia continues, "Surely one of the most frequent justifications courts give for choosing a particular construction is that the alternative interpretation would produce absurd results, or results less compatible with the reason or purpose of the statute." I repeat, I'm quoting Antonin Scalia, "the reason or purpose of the statute." This, it seems to me, unquestionably involves judicial consideration and evaluation of competing policies to determine which one will best effectuate the statutory purpose. So in my view, this passage is remarkable. It expressly draws upon the fundamental classical concept, complete with Latin maxim, that the law consists of reason as well as fiat. The law consists of principle as well as dictate. And that when reason runs out, so does the interpretation of law as lex. Even lex is to be understood as an ordination of reason. And this is one of the essential elements of Aquinas' definition of law as an ordination of reason to the common good. Parenthetically, to complete the classical definition by adding the last element, the common good or public interest or general welfare, we'll shortly see that original Scalia also thinks and says, in terms that would be entirely familiar to the classical lawyers, that it's a fundamental feature of all law that it must be understood as ordered to the public interest rather than private interests. And more remarkably still, the passage I quoted is emphatic that evaluation of policy is part of the traditional judicial armory. I think that's a claim that might startle those for whom anything of the sort amounts to result-oriented judging. But what exactly does Scalia mean by policy here? Does he mean judges considering what is the right minimum wage? I don't think so. In the very same year, 1989, in his concurrence in Green v. Bach Laundry, original Scalia helpfully explains his conception. Nowadays, the Bach Laundry concurrence is cited mostly as an early statement of Scalia's concerns about legislative history. The concurrence combines that critique, however, with a clear recognition that judges should apply a doctrine of absurd results when necessary, using legislative history to identify absurdities. Scalia is explicit about that. And with the view that the ordinary meaning of statutory text should be read in the way most compatible with the surrounding body of law into which the provision must be integrated, a compatibility which by a benign fiction we assume Congress always has in mind. Most importantly, however, Scalia argued that the interpretation he advanced in Bach Laundry was preferable not only because it avoided an absurd result, but because it was the interpretation that was, quote, as he put it, consistent with the policy of the law in general. The policy of the law in general. And in Bach Laundry, this was the general legal policy, according to Scalia, of providing special protection to defendants in criminal cases. Now, Scalia doesn't cite any positive provision to identify this general policy of law. And there's no, of course, provision that directly says defendants should get special protections in criminal cases. There are provisions that give defendants particular limited protections. But you see what Scalia's done is he's extrapolated and in fact drawn from very ancient roots, a more general policy of the law without reference to particular positive laws. And I suggest that his formulation here, the policy of the law in general, is exactly what you would expect a kind of smart, learned, modern judge to come up with as a translation of the term use. It's just a formulation or translation of that idea. Well, if in 1989 Scalia glossed policy as the policy of the law in general, don't we have to know, after all, which sense of law he meant in this setting, lex or use? We do, and happily he had explained that the year before in his 1988 separate partial dissent in Webster v. Doe, which is probably the best exposition of use to appear in the U.S. report since roughly World War II. In fact, the Webster dissent offered not merely an account of law, but an interpretation of the statutory term law itself as used in a famously obscure provision of the Administrative Procedure Act on the reviewability of agency action. So this provision states that judicial review applies except to the extent that statutes preclude judicial review or agency action is committed to agency discretion by law. Well, the majority opinion by then Chief Justice William Rehnquist read the second half of this provision to exempt agencies from judicial review when there is no law to apply, so the agency has a law-free zone of discretion. And this reading is strikingly reminiscent, I think, of the thin legal universe of Hardian positivism, in which there's a positive law, lex, and there are zones of empty law-free discretion, but there's nothing else. Scalia entirely rejects this reading and reads the provision very differently. And he starts with the observation that there's always law to apply. He says there's no governmental decision that's not subject to a fair number of legal constraints precise enough to be susceptible of judicial application, beginning with the fundamental constraint, he says, that the decision must be taken in order to further a public purpose rather than a purely private interest. Now, this fundamental constraint is one for which he cited nothing at all. There's no citation to the Constitution or statute when he says that. What he's done is simply translate a kind of essential of the classical view of law, which is that it be ordered to the common good rather than to private interests. So this vision of the public interest as the omnipresent and implicit aim or end of all laws is one that would have had the classical lawyers nodding in agreement. Okay, so for Scalia, what exactly does the APA provision then mean when it says that agency action may be committed to agency discretion by law? Well, original Scalia gives us an account, and the account hinges expressly on a distinction between positive statutory provisions on the one hand and more general principles of law on the other, between lex and use. He says the key to understanding committed to agency discretion by law lies in contrasting it with statutes preclude judicial review elsewhere in the APA. Why statutes for preclusion, but the much more general term law for commission to agency discretion? The answer, I'm still quoting Scalia, is that the latter was intended to refer to a body of jurisprudence that had marked out with more or less precision certain issues and certain areas that were beyond the range of judicial review. That jurisprudence included principles ranging from the political question doctrine to sovereign immunity, and he goes on. Note here that the principles to which he refers, although adopted by courts, were themselves adopted as a recognition of existing law in the sense of use. So an example is the sovereign immunity of the United States. In United States v. Lee in 1882, the court identifies the sovereign immunity of the U.S. as a general background principle of law. It says that the principle of sovereign immunity, quote, has been adopted in our courts as a part of the general doctrine of publicists. Now that language is obscure to us today, but what it means in the language of 1882 is the classical juristic doctrines of the jus gentium or law of nations. That's what a publicist is. A publicist is a jurist like Grotius or someone who identifies principles of the law of nations. The key to understanding Scalia's account of reviewability, then, is that he draws a distinction between law as lex and law as use. Okay, I'm almost done reconstructing the views of original Scalia. The last question is the one I adverted to earlier. Who decides? So we have this separate legal question about who exactly is authorized to apply interpretive equity or epikeia. Who holds this authority in the circumstances of the administrative state? That's a puzzle for us because we can't directly transcribe or transliterate the classical view to our unwritten constitutional order because the structure of institutions has changed over time. What we need is a translation that preserves the underlying principles of the classical approach in a new setting. So original Scalia solves this problem with an argument for parceling out the traditional interpretive functions of courts, leaving some in the courts and assigning some to agencies in the executive. A critical limitation of the thesis in the rule of law as a law of rules is that original Scalia repeatedly and expressly limits his claim to decision-making by and in courts. So the claim is not that everyone should proceed by general rules, as the court should do so. And this is because, original Scalia argues, the administrative state is above all the locus of authorized, case-specific dispensing power. It's the place in which general statutory schemes are adjusted in hard cases of indeterminacy to the public interest. As he puts it in 1989, broad delegation to the executive is the hallmark of the modern administrative state. And whereas the legislature generalizes, executives and judges handle individual cases. Now, when he says judges handle individual cases, we've already seen he means according to general rules. But the executive is different. The executive for Scalia is the one who is authorized to fill in gaps and ambiguities under a chevron. So it fits together, right? I believe. Now, in order to enforce this general delegation to the executive, Scalia argues, we have to reject any idea that Chevron deference is a mere residual that applies only when judges have exhausted all the traditional tools of statutory construction. As original Scalia protested in his 1987 concurrence in a case called Cardozo-Fonseca, this approach, saying use all the traditional tools and then only then decide whether there's an ambiguity, would make deference a doctrine of desperation, authorizing courts to defer only if they would otherwise be unable to construe the enactment at issue. This is not an interpretation, but an evisceration of Chevron. Rather, original Scalia's view of Chevron rests on exactly the sort of benign fiction based on the overall policy of the law in general, law's use, that Scalia urged in Bach Laundry. The benign fiction here is that Congress is taken to have as a general default rule authorized agencies to resolve hard cases by filling statutory gaps and ambiguities and making the policy judgments that would otherwise be part of the traditional tools of statutory construction. That part of the traditional function has been hived off and assigned to agencies. All this translates into the world of the administrative state, the classical view that magistrates lacking the power to enact statutes can nonetheless serve as the living voice of the law. Original Scalia's view, in effect, translates the classical tradition by preserving all the interpretive functions as it identifies, but dividing them across institutions to the extent possible, urging that courts follow general rules of lex, while creating a benign fiction attributed to Congress to authorize agencies to wield case-specific equity in indeterminate cases. This is a way to specify the classical view for our unwritten constitutional order, the administrative state. Well, so far I've said little about originalism at the level of constitutional interpretation. Originalism of the original Scalia, in many respects, fits this picture well. So in Originalism, A Lesser Evil, Scalia argues at some length that adjudication based on the original public meaning better constrains judicial discretion than do the available alternatives, and thereby promotes the public interest. Now, this is a point about adjudication strictly. It's not a point about interpretation as such. Nothing in this picture at all suggests that originalist interpretation generally is required by the very idea of written law or written constitutions, or is inherent in the nature of communication, or anything of that sort. Scalia also expressly concedes that originalism is not and has perhaps never been the sole method of constitutional exegesis. And finally, what was his point in arguing for originalism as a constraint on judicial discretion? He had a point, and his point was to protect and expand executive power. The pretty much only example he uses in the article is Myers v. United States, which is the decision that is kind of the charter of an expansive presidential authority in our constitutional order. And this is what Scalia is trying to justify in his piece on originalism as the lesser evil. It, I think, fits with everything else I've said. It fits his basic judicial institutional point, which is to tether judicial discretion to the implementation of general rules in order to allocate discretionary exercise of judgment in particular cases to the executive. Indeed, original Scalia doesn't ultimately care about originalism at all for its own sake. What he cares about is finding a constraining mechanism. And elsewhere in the article, he says, well, if originalism won't work, traditionalism will work. And separately in his jurisprudence, I can't get into this, but he was exploring using tradition defined at a low level of generality as the constraining mechanism. For him, neither originalism nor traditionalism mattered for their own sakes. What he cared about was this allocation of authority between judges and the executive. And what he cared about was a powerful administrative state headed by a powerful president. Now, there's one passage in the article, I won't bore you with it. It presages the later jurisprudential turn that many have diagnosed in the dizzying array of post-Scalia versions of originalism, many of which attempt to ground originalism in the very nature of law or language or constitutions or our Constitution or really anything other than a contingent judgment about the public interest, which is what Scalia was making. And I think that passage foreshadows the coming of evolved Scalia. So let me now turn to that process, the process of evolution. For a long period after his miraculous year, original Scalia elaborates on the basic commitments of this model of administrative equity I've laid out. We see him in the 1980s and 1990s defending Chevron against efforts by Justice Stevens and others to issue narrowing interpretations of the decision. We see him endorsing the doctrine of absurd results repeatedly. We see him writing standing decisions that protect executive authority from judicial oversight. We see him authoring Auer v. Robbins, this highly controversial decision that requires courts to defer to reasonable agency interpretations of their own regulations. And he writes one of the court's most expansive modern precedents, rejecting claims under the putative non-delegation doctrine. And this goes on for a while. Indeed, as late as 2012, he authors a remarkable decision called City of Arlington v. FCC, holding that there is no jurisdiction exception to Chevron deference. That is, you can't say, well, the agency's exceeded its jurisdiction, therefore Chevron doesn't apply. In general terms, Scalia was long known as the court's champion of Chevron, of the administrative state, and of presidential power. This is something that's hard to convey now, but he was seen as the justice of the administrative state in fundamental ways. Change, however, is the destiny of mankind, and something did very much change over time, especially towards the very end of Justice Scalia's career. The contrast between original and evolved Scalia grows over time, sort of inconsistently or intermittently, and there are important divergences between academic writings and judicial practice. Already by 1997, when he writes his Tanner lectures, he criticizes the Holy Trinity decision, spars with Ronald Dworkin, and in general has become sort of stricter in his textualism. Even in those lectures, though, he says that the text of the law has to be interpreted in light of the corpus juris. This is a standard Roman term for the whole body of the law. And he quotes and endorses the claim that the rules of the countless administrative agencies are themselves an important, even crucial source of law. And he preserves a notable diplomatic silence about his reliance on the absurdity doctrine, which is still going on. So in 2002, 5 years after the Tanner lectures, he's still endorsing the absurdity doctrine in judicial opinions. In general, his theory and his practice are starting to diverge a bit. It's only later that the practice fully catches up to the changing theory. Let me zoom forward to the period circa 2013 to 2016, when an entirely different model clearly emerges. We see evolved Scalia actually repudiating his own opinion in Auer, and now rejecting judicial deference to agency interpretations of their own regulations. We see him indicating a willingness to reconsider his views about Chevron. Think about that. This was the fundamental paradigm that had structured his whole thinking about law. More broadly, we see evolved Scalia becoming increasingly critical of the administrative state and increasingly reliant on, in my view, a simplistic distinction between law and result-oriented policy conceived as outside of law. And this is a direct contradiction of his earlier views. Rather than rehash all his late judicial opinions, I just want to focus on one remarkable episode in January 2016. This is barely a month before Justice Scalia passed. He was invited to the Dominican House of Studies in Washington, D.C., and he elected rather boldly, given the expertise of his audience, to speak on St. Thomas Aquinas and the law. I assume, Aquinas was a Dominican friar and theologian. So this is the audience that understands Aquinas. And Scalia says, despite my veneration for Thomas Aquinas, I plan to contradict what Aquinas says about judging. It is necessary to judge according to the written law, period. So we've lost several parts of the classical view. He addressed the role of dispensation in Aquinas' theory, which to repeat is just part of the Aristotelian theory Scalia had previously defended. I stand with Aristotle. And he compares Aquinas' theory to the judicial approach of William Brennan. He makes no mention whatsoever of the administrative state or the role of agencies. He even, in response to a question about Nuremberg, denies that there is any basis in higher law for holding Nazi officials accountable. What then was the basis for holding Nazi officials accountable? Well, as one of the friars testified or recounted in a subsequent article, to justify the war trials, Scalia instead simply maintained that, as he saw it, winners in a war have a right to punish the losers. I'm not sure what right means in that sentence. The Scalia of 1989, whose views so closely track the classical structure of interpretive theory, is nowhere to be seen. And his jurisprudence has become flattened and simplified in a certain way. Well, I'm almost done. I just want to close with a few thoughts about what, if anything, this shows about the conservative legal movement. It's beyond the scope of my aims here to offer an explanation as to why exactly this evolution occurred, if such it may be called. But I do have two observations that are inevitably going to be controversial about the larger significance of my distinction between original and evolved Scalia. First, I do think that Justice Scalia's intellectual odyssey in many ways recapitulates and provides a kind of synecdoche for the transformation of the conservative legal movement in the same period. As of 2022, the movement is, in my view, operationally dominated by a libertarian strand of American conservatism that is intensely suspicious of the administrative state while officially denying that it has any substantive views. It's a kind of libertarianism in the lion's skin of Scalia's methods. It is nonetheless, however, entirely willing to abandon the larger structure of original Scalia's classical jurisprudence and his model of a strong administrative state led by a strong presidency. So Don McGahn, who was a former White House counsel under President Trump, and who played a crucial role in the selection of Justices Gorsuch and Kavanaugh, assessed the situation in an episode recounted in a recent book by Ruth Marcus. As McGahn told the Federalist Society, this is Marcus, as McGahn told the Federalist Society, the greatest threat to the rule of law in our modern society is the ever-expanding regulatory state. And the most effective bulwark against that threat is a strong judiciary. It was now all about regulatory relief. On that score, McGahn said Scalia, quote, wouldn't make the cut. So Marcus quotes McGahn as saying Scalia wouldn't make the cut. In my view, in a sense, McGahn was quite right given his own premises and aims. That is, in the conservative legal movement as it currently stands, the jurisprudence of original Scalia has no place. Second, and conversely, the revival of classical legal theory is in part an attempt to return to original Scalia in preference to evolved Scalia. Unsurprisingly, perhaps, this is roughly the structure of the interpretation of the American administrative state that I and other scholars have offered in recent work. I believe, or at least I hope, that this isn't because I'm projecting my views onto Scalia, but quite the reverse. It's because original Scalia impressed his views onto me, circa 1994 to 1995, so that my views are consistent with and amplify upon those of original Scalia, whose views were in turn consistent with and translate those of the classical tradition. At a minimum, I hope that when legal conservatives claim continuity with Scalia's views, we will all get in the habit of asking a particular question. We should ask, which Scalia, original or evolved? In this case, if no other, I proudly count myself an originalist. Thank you.
Well, it is always a joy to be back in Cambridge. It is an honor to be here as part of this lecture series, to be on the stage with two of my friends, and to be participating in a lecture series that Justice Scalia gave the inaugural version of. I went to school here during Justice Scalia's Mesozoic period. after his original but before his evolved one. And after I graduated, I moved to Washington, D.C. to clerk for the great Judge David Santel, a judicial mentor I very proudly share with Professor Vermeule. And in fact, Judge Santel was very fond of saying to me then, and has said to me as recently as this Monday afternoon, the following quote that he told me I was allowed to share with you from Justice Scalia. He said, quote, Adrian, which I would never call him, but Professor Vermeule is the only person ever to clerk in the Scalia chambers and the Santel chambers and to be a conservatizing influence in both. So far be it from me to dispute Professor Vermeule's understanding of any version of Justice Scalia. But I have two questions that I would sort of pose in response to Professor Vermeule's lecture today. One is about the facts. One is about the law, and then I will briefly sum up with a place where I think the two of us wholeheartedly agree. First, on the facts, as we're thinking about the original Scalia, I wonder whether the picture is missing two particular colors. Because when I think about the original or early Scalia, I think of two of his most towering opinions, separated by 7 months in 1988 and 1989, the Honest Mirabilis. I did not hear Professor Vermeule mention either of them, so I throw them out for discussion. The first is Morrison versus Olson from 1988, and the second is Mistretta versus United States from 1989. And these were both solo opinions, just like Green v. Bach Laundry and Webster v. Doe. And in some ways, they pose a different picture of the original Scalia and what Justice Scalia was thinking about, in particular when it comes to executive power. So in Morrison, Justice Scalia stood alone in his belief that the independent counsel statute was unconstitutional because it violated the separation of powers. And he called the separation of powers something our Constitution established to preserve individual freedom. Those are Justice Scalia's words. As he put it, quote, the framers of the federal Constitution viewed this principle of separation of powers as the absolutely central guarantee of just government. Without a secure structure of separated powers, our Bill of Rights would be worthless, Justice Scalia said. And he saw it as his judicial duty to, quote, effectively resist the gradual concentration of the several powers in the same department. This is referencing Madison and Montesquieu and the debates at the founding about the accumulation of powers in single hands. He said, sometimes threats to the separation of powers come to the court clad, so to speak, in sheep's clothing, but in his view, the independent counsel statute and the delegation effectuated by it is a wolf that comes as a wolf. Now, I suppose if it was just Morrison, you might say, well, that's a defense of executive power because Justice Scalia, as he understood it, and he was resisting an executive power that had been taken outside of the executive branch in some ways. And so, and I think that would be totally consistent with what Professor Vermeule has said today. But 7 months after Mistretta, we get another decision. And this one I think is a little bit harder to square, or at least if we can square it, it is painting the picture in slightly different hues. Because in Mistretta, Justice Scalia stood alone in concluding that the guidelines promulgated by the United States Sentencing Commission were unconstitutional. And he, with disgust that is virtually seething through the pages of the United States reports, he calls the Sentencing Commission, quote, a junior varsity Congress. And he remarks that, quote, it is difficult to imagine a principle more essential to democratic government than that upon which the doctrine of unconstitutional delegation is founded. Except in a few areas constitutionally committed to the executive branch, the basic policy decisions governing society are to be made by the legislature. And then this is the conclusion of that paragraph. Our members of Congress could not, even if they wish, vote all power to the president and adjourn sine die. So why are these cases so important? Well, by all accounts, I think Morrison and Mistretta rank among Justice Scalia's most powerful dissents. They're literally in the book, Essential Scalia. And Scalia was particularly fond of them and would reference them from, I think, in his early period, his Mesozoic one, his evolved one. But the real reason that they're important, I think, is because they tell us something that was central to Justice Scalia and his understanding of law in all of his periods. And that's the separation of powers. So in Morrison and Mistretta, he rails against the Congress and its efforts to delegate. He chastises efforts on Congress to blur the lines between the legislative, executive, and judicial departments. And he even quotes Madison, quoting Montesquieu, for the proposition that tyranny results from the accumulation of powers, legislative, executive, and judicial, in the hands of one body. So I don't know if this would necessarily change the conclusion that Professor Vermeule gave us, that the major point of Justice Scalia's, or the original Scalia's, was necessarily or expressly to protect and expand the executive power, at least the way I read them, or at least I understood them when I was at this august institution. Both Morrison and Mistretta stand for a different proposition, namely that the allocations of powers made in the Constitution must remain inviolate, right? That none of them can be expanded at the cost of any other. Now, it's quite right, I think, Professor Vermeule is quite right to say that the early Scalia recognized a distinction between positive law and background unwritten law. I suppose we might reasonably disagree about whether and to what extent the evolved Scalia lost that, because I think, at least the way I read some of his later opinions, he's still focused on it. But to the extent that the original Scalia understood any background proposition or principle of general law to trump others, it would strike me that the paramount principle was the separation of powers. For example, this is from Morrison. From Morrison. This is the original Scalia's quotation in Morrison. Quote, "It is a truism that constitutional protections have costs. While the separation of powers may prevent us from righting every wrong, it does so in order to ensure that we do not lose liberty." So those don't sound to me, anyway, like the words of a man who thinks that courts or administrative agencies or some other body necessarily have the power to right every wrong or to grant case-specific dispensations. At least those words sound like the words of someone who understands the Constitution to separate governmental powers in a way that places such case-specific dispensations out of bounds for the sake of preserving a broader constitutional structure and the general principles of liberty embedded in the document. Finally, a point where Professor Vermeule and I wholeheartedly agree. The question of who legitimately decides is of paramount importance. I agree 100%. That was obviously important to Aquinas. It was important to the American founding. And I believe, as Morrison and Mistretta illustrate, I think it was important to what Justice Scalia thought as well. As far as I can tell, however, it's not the central focus of early Scalia's thinking about administrative law. So I read and reread the administrative law lecture that Justice Scalia gave at Duke in 1990, and then Professor Vermeule referenced earlier this afternoon. And I agree with my dear friend that it does support his arguments in some ways, definitely about Chevron. For example, he is quite right that Justice Scalia was more trusting of Chevron in 1990 than he was in later years. But I do wonder whether it fits neatly into the broader discussion that we've had this afternoon. Because, for example, Justice Scalia concludes that lecture by pointing out that he is less willing to defer to administrative agencies because he thinks the statutory text is going to be clearer in most cases than perhaps other jurists might. So if you read the statutory text and see clarity at the first step of Chevron, then you don't necessarily get to the second one. So even in 1990, I wonder whether original Scalia's understanding of Chevron's domain was perhaps narrower than most. And more to the point of our sort of present discussion, I don't see any part of that original lecture that defends Chevron or any other principle of administrative law as an answer to the who legitimately decides question. Rather, the way I read it, anyway, is I think that Justice Scalia's defense of Chevron in 1990 was a very pragmatic one. What he says is that Chevron, quote, reflects the reality of government and hence adequately serves its needs. In the sense that Congress wanted to make expansive delegations and administrative agencies wanted to wield power delegated to them. And it wasn't until much later in his career that Justice Scalia confronted the question, I think, that hangs over so much of our debates today, which is even if the natural law tradition has a discernible monolithic content when it comes to these sorts of questions, and even if it's true that Roman magistrates had significant powers to exercise dispensations, what does that say about the original meaning of our Constitution and its vesting clauses and the vast array of administrative agencies that do more than exercise such dispensations today? And when Justice Scalia got around to wrestling with those later questions, or those latter questions, his approach seems to me to be deeply rooted in our Constitution and the debates that our founders had in the 1780s about how we the people did in fact and should organize the government. As far as I can tell, he's not, in those later years, wrestling with Aquinas. I agree with Professor Vermeule on that. And I don't know if it was necessarily rooted in Aristotle's Politics, which Professor Vermeule again referenced today. But I would suggest that Justice Scalia's evolution was rooted in Aristotle's Ethics. As you know, Aristotle thought that a life well lived, a life of virtue, was a pursuit of an unattainable yet still worthwhile goal, and that each of us hopes that the person that we are later in life is wiser and further in that pursuit than the one we were at 50 or at 25. And that's why I think Justice Scalia wrote in his last full term on the court, quote, "The life of the law is experience." So insofar as the evolved Scalia was a wiser Scalia, one who learned from his decades of experience on the court and to examine previously unexamined premises and to seek answers to previously unasked questions, I'm not so sure that that's a bad thing. And I think Aristotle, at least, would have admired the effort. Thank you very much for having me today.
So I'm grateful to be part of this conversation and to Adrian for this incredible talk, which has helped me reform my own, or reformulate my own views, I hope in a helpful way. And it's an honor, Judge, to be on a panel with you as well. I want to talk about one of my favorite original Scalia opinions, one not mentioned by Adrian either today or in his extraordinary book, Common Good Constitutionalism. This is an opinion written, it is reported, as the opinion was per curiam, not by Justice, but by Judge Scalia, when he served on the DC Circuit Court of Appeals. The case involved the Graham-Rudman-Hollings Act, which was designed to reduce the federal deficit by giving to the comptroller the power to cut the budget if Congress failed to meet certain spending targets. The DC Circuit struck the act. Bauscher versus Sinar affirmed the DC Circuit. Here's the passage of the original Scalia that I want to focus on, discussing the removal cases of the Supreme Court. Quote, "These cases reflect considerable shifts over the course of time, not only in the Supreme Court's resolution of particular issues relating to the removal power, but more importantly in the constitutional premises underlying those resolutions. Justice Sutherland's decision in Humphrey's Executor, handed down the same day as Ayla Schechter Poultry, is stamped with some of the political science preconceptions characteristic of its era and not of the present day. It is not as obvious today as it seemed in the 1930s that there can be such things as genuinely independent regulatory agencies, or indeed that decisions of such agencies so cleanly involve scientific judgment rather than political choice, that it is even theoretically desirable to insulate them from the democratic process," end quote. Now, what's striking about this opinion is that it is Scalia speaking as a legal sociologist. It is Scalia reporting something about us, or at least something about them in the 1980s. It is Scalia telling us something about how they spoke, about what their preconceptions were. Those preconceptions would be familiar to anyone educated at the Harvard Law School in the 1950s. They were realist preconceptions. They would mature into critical legal studies preconceptions here at this school. And according to those preconceptions, when lawyers or judges tell us, they are telling us about science. They are actually telling us about politics. Or at least when they are telling us what science requires, it is, quote, "not so clear that these tellings are the project of scientific judgment rather than, quote, political choice." This realism was central to the original Scalia, too. Think about his opinion in Prince versus United States, striking the Brady Act, rejecting the idea that commandeering state administrators was something different from commandeering state legislatures. Quote, "The government's distinction between making law and merely enforcing it, between policymaking and mere implementation, is an interesting one. Executive action that has utterly no policymaking component is rare. Is it really true that there is no policymaking involved in deciding, for example, what reasonable efforts should be expended to conduct a background check," end quote? Or in other words, is it really not true that it is all politics? Now, there is a subtlety in Scalia's language we should not overlook. Scalia is not telling us how things are. He is telling us how we now view things. He's not rejecting the idea that at an earlier time such a line could be drawn. Whether it could or could not be drawn was a function of them, how they spoke or understood the law. Just because we can't draw that line doesn't mean they couldn't draw the line. Just as the fact that we can't speak Latin doesn't mean that Justice Bradley or most of the best 19th century justices couldn't. What we can do is a function of us and our language and our practice and our culture. That's why I call it a kind of sociology. And what we can't do doesn't entail anything about what other cultures at different times could or could not do. Now, seen like this, Scalia's language should remind us of another extraordinary 20th century justice, also educated at this law school, Justice Louis Brandeis. In one of that century's most important cases, and again, a case not mentioned by Adrian, either today or in his book, the court overturned what was said to be the doctrine of Swift v. Tyson. It wasn't, but let's put that aside. In Erie versus Tompkins, Brandeis said this, quote, "The doctrine rests upon the assumption that there is a transcendental body of law outside any particular state, but obligatory within it unless and until changed by statute. But law in the sense in which courts speak of it today does not exist without some definite authority behind it. The common law, so far as it is enforced in a state, is not the common law generally, but the law of that state, existing by the authority of that state without regard to what it might have been in England or anywhere else." End quote. Here again is a kind of realism. Whatever they may have been able to do in the 19th century, it is not something we can do today. Law, in the sense in which courts speak of it today, does not allow it. And instead, we must craft our practices, and indeed, the Constitution, for remember, Erie declared the practice of federal general common law unconstitutional, according to our present speaking abilities. Now, I say all this because I want to suggest that at the heart of Adrian's extraordinary work, both his analysis of Scalia today and his book, is a presumption about our abilities today that I don't think we can take for granted. Adrian's work asks us to reimagine, so we might practice again, the classical model of law. In this classical model, law is both lex, what legislatures presumptively write, and use, the principles and traditions and morals behind that lex. Scalia, Adrian said, aims to translate, I love the citation with hands like that, that was nice, translate this classical model to the American constitutional order, and in doing so recognizes an unavoidable need for the law applier, whether judge or administrator, to make, quote, dispensations, quote, case-specific adjustments of vague, ambiguous, or overly general language to particular circumstances in order to promote the public regarding purpose, so the purposes the legislator had in view, end quote. Adrian urges, not so much here today, but in his book, a return to this practice. And now he bolsters the argument for that return by invoking the Scalia that is easiest for most of us to accept or respect, the original Scalia. But the question I want to press, drawing upon the Scalia from Sinar and Prince, and inspired by Brandeis in Erie, is this. Are we, as a legal culture, today, capable of this practice? This classical model practice anymore? Are we skilled in it? Could we imagine teaching it to our students? And more pressingly, are we able to imagine these administrators, whether courts or agencies, engaging in a practice of, quote, adjusting vague, ambiguous, or overly general language to particular circumstances in order to promote the public regarding purposes that the administrator believes the legislator had in view, without viewing such adjusting as just another example of politics? because such a practice presumes something about the legal culture that engages in it. It presumes, in particular, a trust or confidence or good faith. It imagines a culture that doesn't meet every act of a Supreme Court with a skeptical political eye. It presumes that we don't look for the ulterior motive, a political motive, behind every single decision and speak about that openly, as we do, for example, about Dobbs or Bush v. Gore or whatever, because presumptively, the institutions have not given us any reason or any good reason not to be so suspicious. Yet I would submit our culture today is not the culture the classical model presumes. Whether justified or not, our culture today, our legal culture, is profoundly suspicious, profoundly skeptical. And in our culture today, whenever any court, or from the perspective of the DC Circuit, any agency, acts, we do not presume it acts in the public interest. We instead suspect it acts for a political interest. That's not necessarily partisan, but it reads to most people like that. And what that means is that any act of dispensation becomes presumptively illegitimate, at least when it comes down on one side of an issue seen to be plainly or clearly political. Now, my sense is Scalia sensed this, and that what explains his evolution, his abandonment of the classical model, is not so much him as his perception about us, about the law in our legal culture today. And I would agree with his perception. What explains his apostasy is the belief that, to remix Steiner, such, quote, dispensations, end quote, do not so clearly involve public regarding purposes rather than political choice. Or to remix Prince, quote, is it really true that there is no policy making involved in deciding, for example, what this proper, quote, dispensation, end quote, would be? Or finally, to remix Brandeis, that law in the sense in which courts speak of it today does not exist without some definite politics behind it. And that the job of the courts, in Scalia's evolved view, is to minimize as much as possible any action that might seem to be the product of such politics. From this perspective, Scalia's words, but a month before he passed, make perfect sense. Quote, despite my veneration for Thomas Aquinas, I plan to contradict what Aquinas says about judging. It is necessary to judge according to the written law, period. Why? Because it is right always and everywhere in every culture? Or because it is right for us, given our deeply realist legal culture now? I suggest the evolved Scalia has simply translated Thomas Aquinas, or the classical tradition, from a very different legal culture to our own, very skeptical legal culture. Or more precisely, that Scalia has translated Aquinas in light of his recognition of the public regarding purpose that Scalia believed the Constitution imposed upon the court to minimize judicial acts that might be seen as political acts. Or we might say, the evolved Scalia is simply the original Scalia translated, respecting fidelity to Aquinas' meaning, subject to the constraint of the judicial role. I'd love to explain how this applies to administrative agency, but alas, I've run out of time, so I don't. Thank you very much.
I have just some very brief thoughts for both of our respondents. First of all, thank you for those wonderful responses. I basically have one citation for each of you, but I'm going to explain the citations. So let me start with Judge Oldham. Judge Oldham references Morrison, but then rightly, I think, says that that's consistent with the view I laid out. But his real stress is on Mistretta. And he says that Mistretta is a case in which Justice Scalia invoked the non-delegation doctrine as a way of enforcing the separation of powers. I left Mistretta out because I thought it was so clear that it fit my thesis. And the reason I left Mistretta out is that I think Judge Oldham stopped reading Mistretta a bit too soon. The very next paragraph, after Judge Oldham stopped reading, says, while the doctrine of unconstitutional delegation is unquestionably a fundamental element of our constitutional system, it's not an element readily enforceable by the courts. And Scalia goes on to explain why the non-delegation doctrine isn't suitable for courts to enforce on exactly the sort of grounds I gave. And he ends up rejecting, he agrees with the court majority. He says, I fully agree with the court's rejection of petitioner's contention that the doctrine of unconstitutional delegation of legislative authority has been violated in this case. What he then goes on to do is to articulate a much narrower ground of decision that has to do with bodies that don't otherwise have statutory authority making rules. I won't get into that. But the baseline fact of Mistretta is that Scalia is rejecting the non-delegation claim and explaining at some length why courts aren't suitable to enforce delegation claims. I think this fits original Scalia perfectly in a certain sense. And I just wanted to say that I worry that Judge Oldham heard me to say something I didn't mean to say, which is that original Scalia denies the validity of the separation of powers as a principle or something of that sort. Quite the contrary, he's offering an interpretation of the separation of powers. His whole idea is, how are we going to allocate classical interpretive functions across branches in a way suitable to the different powers and capacities of the branches? It's not in any way a denial of generalities about the separation of powers, it's a vision of the separation of powers. So I think he would perceive no inconsistency in saying, yes, I adopt from Madison the separation of powers, and here's how I think it works along classical lines. So those are my thoughts for Judge Oldham. For Larry, I thought there's a characteristically just a brilliant turning of my argument. But I think it rests on an ultimately empirical claim that I think is false. A claim about our culture. Let me explain why I think it's false. Don't believe me. Believe an experimental, so-called experimental jurisprudence. There's this new group of people who do what's called experimental jurisprudence. And they do large number of surveys and so forth and try to find out what people think about law, where people includes both people off the street and practitioners of law. And this guy's name is Brian Flanagan, and he recently published a paper called The Natural Concept of Law, the Folk Concept of Law. Law is intrinsically moral. And he did a large number survey, and he found that we report a set of studies that conflict unexpectedly with the predictions of legal positivists. Intuitively, for example, an evil rule is almost universally seen as not a fully fledged instance of law or not law at all. So when Larry says our legal culture rejects the classical vision of law, I want to say, who is the R? I don't think it's R widely in society. I don't think it's even our judges, in the sense that I argued at length in my book that when judges stop doing theory and start actually deciding cases, they constantly fall back on claims about what we would be entitled to call natural law. They fall back on claims about use. I think when Larry says it's our legal culture, what he means is that it's the legal culture of a very small set of academics at a very small set of schools who are firmly committed to a kind of legal realism and who firmly think that all there is politics. But I don't think that that is our culture in any widespread or broad sense. And indeed, I think a lot of law school is focused on beating natural intuitions about jurisprudence out of students. And we affirmatively produce this kind of realist view, but that's a product that we are pushing in a way. And I think when they go on the bench, they often abandon it because of the sort of intuitions that experimental jurisprudents like Brian Flanagan have identified. Okay, thank you both.